covered. Okay, so let's start with this case. It was two judges, a bench, Krishna Murari and Abdul Nazir, right? It was about the daughter's right to inherit self-acquired property of father dying intestate, recognized under customary Hindu law, right? So if a father, he dies intestate, and do you know the meaning of intestate? Can someone tell me? There are two types of, yes, without will, thanks. Testamentary succession and intestate succession. I hope you all are aware. Testamentary succession is about how it happens. Yes. How the testamentary succession happens?
Ma'am, succession by will.
Succession by will, right. So that happens with will, and intestate is without will. Okay. So in this case also, if a father has got self-acquired property, now self-acquired property is not a coparcenary property, right? Coparcenary property is your inherited property or your, parental property, but self-acquired property is something that you acquire or you get through your own income, through your own labor, right? So if the father has self-acquired property and he has a daughter and he dies intestate, then the daughter will inherit the self-acquired property of her father, right? So I'll give you the brief facts about this case. This is a diagram that they have given in the judgment itself. All right. So this suit for partition was filed by this Thanakamal. Okay. Thanamagal, she is the daughter of Ramaswamy Gounder. All right. This 2 number, if you see here, if I think you can see my arrow. So this G Thangamal, she is the daughter of Ramaswamy. Okay. Ramaswamy Gounder, right? Claiming 1/5 share in the suit property. All right. So she wanted 1/5 share in the suit property on the allegations that the plaintiff and defendant number 5 and 6. All right. This is the defendant number 5, Ilayammal, and this is the Nalammal. Okay. So these are the plaintiff and the defendant numbers 5 and 6, right? That is Ilayammal and Nalammal, and one Ramaya Ammal. So this Ramaya Ammal, she is deceased. All right, they are sisters of Gurunath Gounder. Gurunath Gounder, right? So Ramayammal, Ilayammal, and Nalammal. These all are sisters of Gurunath Gounder. Ramayammal is dead. Ilayammal, she's a daughter, and she's also defendant number 5 in the suit. Okay, and Nalammal, she's daughter and defendant number 6 in the suit. All right. Now, all the 5 of them, which means Gurunath Gounder, Thanagammal, Ramayammal, Ilayammal, and Nalammal, right? All 5 of them are the children of Ramaswamy Gounder. All right. Now, this Ramaswamy Gounder, he had an elder brother whose name is Marappa Gounder, right? Now, Ramaswamy Gounder, he predeceased his brother Marappa Gounder. Predeceased means he is dead before Marappa Gounder, right? So that is predeceased. He's dead before Marappa Gounder dies, right? So Ramaswamy Gounder, he predeceased his brother Marappa Gounder, and Marappa Gounder, he died. Ramaswamy Gounder, he died on some date, 14th April, I think 1957, right? And he left behind the sole daughter. Marappa Gounder, he died, right? Ramaswamy predeceased Marappa Gounder, and Marappa Gounder, he left sole daughter, whose name was Kupai Ammal. I'm really sorry. These pronunciations are a little difficult. Kupai Ammal, right? She's also dead issueless in 1967. Issueless means having no children, right? So she's dead without. Yes.
Ma'am.
Yes.
It's Kupai Ammal.
Oh, Kupai Ammal. Thank you.
Ammal, actually. We pronounce it Ammal.
Ammal. Yeah. All right. Thank you. I am really sorry because I might not be good in pronouncing these names. It's a bit difficult for me. Okay. So Kupai Ammal, she was dead in 1967. Issueless. Issueless means having no children, right? Further case set up by the plaintiff, or you may call it as appellant, was that after the death of Marappa Gounder, right, his property was inherited by Kupai Ammal, right? And upon her death, so Marappa Gounder death, the property will be inherited by Kupai Ammal, and upon her death, right, in 1961, all the 5 children of Ramaswamy Gounder, like Gurunath Gounder, then Thangammal, right? She's the original plaintiff. But she was the original plaintiff, but now she's represented by her legal heir, right? Then Ramai Ammal and Elaya Ammal and Nalammal are heirs in equal of Kupai and entitled to 1/5 share each. Now, I don't know if you guys know how to calculate the share, but you have to calculate the number of members of a family and then 1/5. So 1, 2, 3, 4, 5, right? All of them are eligible for 1/5. But in the beginning, the property, how it will be divided, suppose Gurunatha Gounder is there, Marappa Gounder, Ramaswamy Gounder. The property will be 1/3, 1/3, 1/3 each, right? But suppose Gurunatha Gounder dies, right? And now Marappa Gounder and Ramaswamy Gounder is there, right? Then how the property will be distributed, tell me? What will be the property of Marappa Gounder and Ramaswamy Gounder then? Yes, branch basis, but tell me the number. Right, 1/2. Gurunath Gounder died, then one Marappa will get half, Ramaswamy will get half, right? Now this half a property of Marappa Gounder, right, that will obviously go to Kupai Ammal. Now, once the Kupai Ammal is dead, then again it will be divided. So this is a calculation difficult, but anyway, that will not be asked in your CLAT, so I'll not go into it. All right, so they are asking that we should get the 1/5 share because Kupai Ammal is now dead. Now, Gurunatha Gounder, who died leaving behind the defendant numbers 1 to 4, right? Ponnusamy, Thanagammal, Papai, and Kanammal. These are defendants 1 to 4, right? Gurunatha Gounder died and he left these defendants behind, right? They are respondent, all these are respondents, okay, or defendants as heirs and legal representatives. Then Ramai Ammal, right? She died leaving behind defendants 7 and 9. All right. And the plaintiff appellant here, right, who is the Thanagammal, right? She died leaving behind appellants 1, 3, and 4. You don't have to remember the numbers, just understand the brief facts. And then appellant number 1, who is Arunachala Gounder, right? And Arunachala Gounder, she's also dead. And she is represented by her legal representatives, appellant number 1, that is Venkatachalam, and appellant number 2, that is Mutayappan. Now, the defense that was set up by the defendant respondents was that Marappa Gounder, he died on 11th May 1949, right? And not on 14th April 1957. So there was a date confusion. Defendant was saying that he actually is dead on 11th May, right? Not on 14th April 1957. Dates are important here, right? Do you know why the dates are important here in this case, 1949 and 1957? Anything that comes to your mind? Yes, Act 1955. Which act? Right, Hindu Succession Act. Thank you. All right, so they are saying that he is actually dead on 1949, but not on 1957. Right? That is as per the provisions of Hindu law prevailing prior to 1956. Right? Gurunath Gounder was the sole heir of Marappa Gounder, and accordingly he inherited the suit properties and he was in possession and enjoyment of these properties. And after his death, the respondents were continuing as lawful owners. Right? Now, this was a disputed fact between the parties that the property in question, right, that is the suit property, was independently purchased by Marappa Gounder in the year 1938. So these parties are saying that Marappa Gounder has independently purchased that property in the year 1938, like through the process of a court auction, right? And therefore, it is his independent property. But there was an issue between the parties in respect of the date of death of Marappa Gounder, right? The plaintiff appellant here, right, she asserted that the death was happened on 1957, whereas the defendant respondent, they are saying that the death happened in 1949. Then it went to the trial court. Trial court considered all the evidences, right, and they concluded that Marappa Gounder died in 1949, and therefore the suit property should devolve upon the sole son of the deceased Ramaswamy Gounder, that is Gurunath Gounder. Right? Getting the thing? Is it clear to everyone? The suit property would devolve upon the sole son of deceased Ramaswamy Gounder, the deceased brother of Ramaswamy Gounder, by survivorship, right? Their contention was that the trial court said that the suit property, right, should devolve by survivorship. If all of you know that before Hindu Succession Act 1955 came in, the property used to devolve by way of survivorship. But when the Hindu Succession Act 1955 came in, the survivorship doctrine was abolished, right? So here the trial court is saying, since he's the only son, Gurunath Gounder of Ramaswamy Gounder, and that's why the property will devolve upon him by survivorship. And the plaintiff appellant, that is Thanagammal, will have no right to file the suit for partition, and accordingly the trial court dismissed the suit. Is it clear? Then after the trial court, it went to the High Court. Right? High Court also confirmed the date of death of Marappa Gounder in 1949. Right? That was the first appeal which went to the High Court, and they dismissed the suit of partition, saying that the property of Marappa Gounder will devolve upon Gurunath Gounder by way of survivorship. Okay, and then it came before the Supreme Court. No, you don't have to remember the name and the facts. It's just a story that I told you, like what happened. Simple, you need to remember here the property, the trial court and the High Court, they asked, they ordered the property should devolve by survivorship because this Marappa Gounder, he was dead in 1949, and therefore the doctrine of survivorship will be applicable here. And when the survivorship doctrine will apply, then it will only go to Gurunath Gounder. Is it clear? You don't have to remember the facts. Now the issue. What was the issue in this case? The primary issue, ma'am, what did High Court? High Court simply confirmed the findings of the trial court, saying that yes, he is dead in Marappa Gounder is dead in 1949, right? And therefore they dismissed the suit for partition and said that the property will devolve upon the defendant by way of survivorship. Okay, that is on Gurunath Gounder. Is it clear? Okay. Now the issue in this case was which arise for Supreme Court's consideration is with respect to the right of the sole daughter to inherit the self-acquired property of her father in the absence of any other legal heir having inheritable rights before the commencement of Hindu Succession Act 1956. Or in other words, whether such suit property will devolve onto the daughter upon the death of her father, intestate by inheritance, or shall devolve onto father's brother's son by survivorship, right? So issue was simple because this person, Marappa Gounder, right? He was dead, but he was having some self-acquired property, right? Since he's dead in 1949, so since before 1955 Act of Hindu Succession, survivorship was prevalent with respect to the co-parsonary property, right? So the issue was now Marappa Gounder is dead. Should this property, that is self-acquired property, should this property go to his sole daughter upon his death, upon her father's death intestate by inheritance, or should it devolve upon father's brother, in this case Ramasamy Gounder, by way of survivorship, right? Then this is the primary issue, but then court formulated three issues. What is the nature of the property, and what would be the course of succession if it is a separate property as opposed to undivided property? Undivided property is your co-parsonary property, right? So what is the nature of the property, right? Whether it is co-parsonary property or it is a self-acquired property, and how the succession will happen if it is a separate property, right? That was the first issue. Now, second, whether a sole daughter could inherit her father's separate property dying intestate, right? If there's only one daughter, right? Then could she inherit her father's separate property dying intestate? And what would be the order of succession after the death of such daughter? Now, all of you must be knowing, I'm not really sure, but there is an order of succession, right? Class 1 heir, class 2 heir, then agnate, then cognate, right? That's for your male dying intestate. When females dies intestate, then there is another order, right? Another type of succession. It happens that it is given to the husband heirs. If you read section 15 and 16, right, that talks about female dying intestate. But for male dying intestate, if you refer to section 8 to 13 of Hindu Succession Act, you will understand how this order will be followed if a male dies intestate. All right. So there's a schedule also, schedule appended, wherein if the male dies intestate, then it will go to widow, son, and all that. I mean, there are categories. Class 1 heirs will be given the first priority, then the class 2 heirs, and then agnate and cognates, right? So it's that way. Even if you read section 15 and 16, you will get the order or the priority or the reference how the property should devolve if a female dies intestate, right? Now the court went on to understand the sources of Hindu law. Now this portion is a bit theoretical, which you might have studied, but you need to remember this because they have talked a lot about it in the judgment, right? Hindus believe their laws to exist in the three issues are clear to everyone, right? Because it's a very simple case, but there is a theoretical part which I will be covering because they will ask this theoretical part anyway. Okay. Any doubts? Anyone? If you have any doubts, please let me know. The above, ma'am, please repeat the issues again. Okay. See, the first issue was, what is the nature of the property and what would be the course of succession if it is a separate property as opposed to undivided property, right? See, what is the nature of the property means whether it's a self-acquired property or it is coparcenary property, right? Separate property devolves differently than your coparcenary property, right? If it is an undivided property, then the way it devolves is different. And if it is a separate property, then the way it should be devolved upon the heirs of that person is different, right? So the court wanted to know that if this person, Marappa Gounder, if he's dead and he has a self-acquired property, then what is the nature of that property? Should it be considered as self-acquired property or should it be under undivided property, right? And how the succession will happen if it is a separate property. That's the first issue. Second issue was whether a sole daughter could inherit her father's separate property dying intestate. If a father is dead intestate without making a will and he has got a separate property, then whether the daughter should inherit that property or not. That's the second issue. Third was, what would be the order of succession after the death of such daughter, right? Which means order of succession. I'm not really sure if you are being taught about this. The order, have you been taught about this? Section 8 to 13 and 15 and 16. Yes, anyone? Yes, ma'am, but very briefly. Okay. All right. So there's an order of succession given under these sections, and there is a schedule appended to Hindu Succession Act 1955, wherein you can check the order. Like if the male dies intestate, then the order of succession will happen as per section 8 to 13, and then you'll have to refer to the schedule 1, schedule 2, agnate, cognate, and all that, right? Which means the priority will be given to class 1 heirs first, then class 2 heirs, and then agnate and cognate. So that's for male dying intestate. If a female dies intestate, then the order of succession is different. That is given under section 15 and 16 of Hindu Succession Act 1955, right? So if she dies, then how the property will go? You have the first person, then second person. So that's the hierarchy. You have to follow the hierarchy. So if you don't have those category of people in the first category, then it will move on to the second category, right? So that's the order of succession. That's the third issue. Now, Hindus believe their laws to exist in the revelations preserved in Vedas, right? Shrutis, that which they might ask, like, what are Shrutis, right? That which are heard and revealed, right? That those are Shrutis. And Smritis, in contradiction to Shrutis, that which is remembered. Smritis is something that you remembered. Shruti is something that you have heard and then you are revealing it, right? The Smritis comprise forensic law or the Dharma Shastra and are believed to be recorded in the very words of Lord Brahma. So what are Smritis? Smritis consist of forensic law, right? And or you may call it as Dharma Shastra, right? And Smritis are actually recorded in the words of Lord Brahma. Now, the Dharma Shastra or forensic law is to be found primarily in the institutes or collections known as Sanhitas. So where will you find this Dharma Shastra or forensic laws? In Sanhitas, right? Smritis, or in other words, the textbooks. Smritis are something that is remembered. So you may find Smritis in the textbooks as well, which are attributed to the sages like Manu, Yajnavalkya, Vishnu, Parasara, and Gautama. Right? You may be asked questions like who belongs to the Smritis, like these are the people, Yanu, Yajnavalkya, Vishnu, Parasara, and Gautama. And on these commentaries, digest and annotations have been written, right? So based on Smritis and Shrutis, the commentaries, digests, and annotations, they have been written. Now, besides these sources, Shrutis, Smritis, and then commentaries, digest, and annotations, you have customs, equity, justice, good conscience, and judicial decisions, which have supplemented the development of Hindu law. Right? Now, the commentaries by various learned scholars have given rise to different schools of Hindu law. Right? There are different commentaries, and that because of which we have got different schools of Hindu law. The major being Dayabhaga and Mitakshara. Right? Dayabhaga prevails in Bengal, Mayukha in Bombay, Konkan and Gujarat, and Marumakkatayam or Nambudri in Kerala, and Mitakshara in other parts of India. You need to remember because they might ask questions on this also, right? The Mitakshara school of law is one of the most important schools of law, having a very wide jurisdiction. It applies to majority of India. All right. Now, these slight variations formed various sub-schools. Now, along with these schools, there were slight variations, and because of which, we have got sub-schools within these schools, Dayabhaga and Mitakshara, which are those Banaras school, Mithila school, Maharashtra Bombay school, Dravida and Madras school. All right. Now, the difference between the two systems arises from the fact that while the doctrine of religious efficacy is the guiding principle under Dayabhaga, doctrine of religious efficacy, which means who is the person who offers, that funeral cake, he will get the property in Dayabhaga. So what happens in Mitakshara? You have to follow the 4 generation rule or the coparcenary property rule, right? And it will devolve by survivorship. But in Dayabhaga, you follow doctrine of religious efficacy, that whoever is the person who offers the funeral cake, he gets the property in Dayabhaga school. They don't have the similar way of partition of the property which is prevalent in Mitakshara. It's a different thing, right? Now, there is no such definite guiding principle under Mitakshara school, which I've just discussed. Sometimes consanguinity and at other times religious efficacy has been regarded as the guiding principle. So in Mitakshara, you don't really have such a doctrine of religious efficacy, but sometimes you might find it, but it's not there. Okay. According to Mulla, Mitakshara recognizes 2 modes of devolution of property: survivorship and succession. Oh, there's a text. Dayabhaga. Yeah, Dayabhaga, in Dayabhaga, how the devolution of property happens is based upon the doctrine of religious efficacy. Right? Now, suppose there's a person A. All right, he's dead. And he has got 2 sons. And now he's dead, but these 2 sons have not performed his final rites, right? Or funeral rites, right? But some other third person, consider his brother or his brother maybe, or anybody, they have performed, they offered the funeral cake to him, like performed his funeral rites. Then that person will also get the preference in getting the property. That's what happens in Dayabhaga school, right? But in Mitakshara, we don't really have this doctrine of religious efficacy, right? In Mitakshara, you have 2 kinds of devolution of property. One happens by survivorship and another is succession. Survivorship is that whoever is surviving, they'll get the property, but they have to be in that 4 generation rule, right? It has to be till 4 generation. Now, suppose there is father F and he has got 2 sons, right? S1 and S2. Then S2, S1 has got, suppose S3, and S2 has got S4 and S5, right? Now father is alive. So the property will go till the branch of S4, not S5, because these are the 4 generations. The moment father dies, then only the S5 will enter into the coparcenary property and then he will get it. So this is survivorship rule. Whoever is survived by the person who is dead, they'll get the property, but you have to follow the 4 generation rule, right? So that's how happens in Mitakshara. And succession is, I have already discussed, succession is a different than survivorship. You have already, it happens based upon your affinity and relationship with that particular person. And those groups are already defined, being class 1, class 2, AILET, cognate, and all that. Okay. All right. So the rules of survivorship apply to joint family property. And the rules of succession apply to property held in absolute severalty by the last owner. Okay. So survivorship is only with regards to your family property, but with regards to succession, whatever the property is held by the last owner, it will apply to that. Okay. Now the Mitakshara has always been considered as the main authority for all the schools of law, with the sole exception of that of Bengal, which is mostly covered by another school known as Dayabhaga. Right? Now, the Mitakshara school derives majorly from the running commentaries of Smritis written by Yajnavalkya. You need to remember this, like who has written the Smriti commentary for Mitakshara school. It's Yajnavalkya. Other important sources governing the Mitakshara school are Vyavastha, Chandrika, and most importantly, Smriti Chandrika. So apart from Yajnavalkya, you have Vyavastha Chandrika, and among that, the Chandrika is the most important, right? Now, the digest of Yajnavalkya states that what has been self-acquired. Now, this is important. Why I have taken this from the judgment is because we never know what kind of questions they'll ask you, right? They might say, they might give you this line and they might ask you that to which school this belongs to, and who has written this digest, from which digest this line has been taken, right? So the digest of Yajnavalkya states that what has been self-acquired by anyone as an increment without diminishing the paternal estate, likewise a gift from a friend or a marriage gift, does not belong to the co-heirs. What Yajnavalkya digest is saying, suppose if you have acquired something on your own, with your own money, right, with your own labor, that is an increment to your parental property, right? You have your parental property, but whatever you have acquired by your own labor, your own money, that is something addition or increment to your paternal estate. That is self-acquired, right? It could be a gift from your friend, it could be a marriage gift, it could be anything. Then that self-acquired property will not belong to the co-heirs. Okay. Now the digest by Sham Charan Sarkar Vidya Bhushan, it is also known as Vyavastha Chandrika, right? This digest says that daughter's right of succession. The name of that digest is daughter's right of succession. I just highlight this. A daughter being entitled to inherit the divided property of her father, it has been by parity of reasoning determined that she is entitled to inherit also such property as was separately acquired or held by him or was vested in him. Okay, so Vyavastha Chandrika said, yes, daughters are already able to inherit the divided property of her father, right? But she's also entitled to inherit the separate property of her father. Okay, now this 34 is Mulla's 34. Okay, book Mulla, if you refer to Mulla's 22nd edition, this is given there. So the court is referring to this paragraph 34 regarding devolution of property according to Mitakshara law, right? In determining the mode in which the property of Hindu male governed by Mitakshara law devolves on his death, the following propositions are to be noted. I've already explained, but let's go through this quickly, that when a Hindu male dies, right? So as per Mitakshara law, how his property will be devolved. Now, the first is where the deceased was at the time of the death, a member of joint and undivided family, right? That is your joint family, technically called as coparsonary, right? I just told you. his divided interest in the copartnery property devolves on his copartners by survivorship, right? Now there's a person, Hindu male. He belongs to Hindu joint family or undivided family, right? He is dead. And once he's dead, his undivided interest means the property is still not divided, right? The property is held jointly, that they have common ownership, right? They have common ownership and community of interest over that property, which means the property is not divided, which is also called as a copartnery property. Now he's dead. He belongs to a Hindu joint family, right? Then his undivided interest in that copartnery property will devolve on his copartners by survivorship. Okay, I told you what is survivorship. Now, second proposition is that even if the deceased was joint at the time of his death, he might have left some self-acquired or separate property, right? He's dead, he's a part of Hindu joint family and he has some undivided interest, but he might also have some self-acquired property, right? Such a property goes to his heirs by succession, right? According to the order given in this 43, but this 43, I'll just mention the section of Hindu Succession Act so that will be better for you. 8(2), section 30. All right, so this property, that is self-acquired property. Okay, self-acquired property will go as per the succession, not by the survivorship, right? And that is as per the order given in section 8(2)(13), and not to his copartners. It will not go to his copartners. Okay, but let me just, maintain the text of the judgment and I will write separately in the bracket. Okay, because I don't want to disturb that text of the judgment. All right, so if the deceased was at the time of his death the sole surviving member of a copartnery property, the whole of his property, including the copartnery property, will pass to his heirs by succession according to the order that is given in 43. Okay. All right. Now he's the sole surviving copartner, which means he's not having any son, any brother, or anyone. He's the only one sole surviving copartner. Then whole of his property will go to his heirs by succession, not by survivorship. Okay. See, copartners are till 4 generations, right? But heirs, he might have other heirs, right? He might have his wife, right? Then daughters, right, got recognized in 2005. Before that, daughters never had a right to get the property from the copartnery property, right? There could be other heirs, right, which are not in the 4 generation, and he's the sole surviving member. Then that property will devolve by the succession upon his heirs as per the order that is given in 43 paragraph of Mulla 22nd edition, right? If the deceased was separate at the time of his death from his copartners, the whole of his property, however acquired, will pass to his heirs by succession according to the same order, right? Now, the deceased, when he's dead, right, he's separate from the copartners, which means he has got his property and now he's separate. He's not staying with the copartners, which means he's separated from the Hindu joint family. Then whole of his property, then that time it will not matter whether it is the copartnery property or the self-acquired property, because that time he is separated from his joint family, then that property will obviously go by succession. Please repeat the first point. Okay. Now, the deceased, there is a Hindu male. Okay. Now, the deceased, there is a Hindu male. He is dead. He belongs to Hindu joint family. Hindu joint family, which you always, you technically call it as coparsonary, right? Why coparsonary? Because in coparsonary, you have 4 generations. You have ancestral property or parental property that devolves by survivorship upon the surviving coparsoners, right? And when you have a Hindu joint family, you have undivided interest in the Hindu joint family, right? And why we call it as undivided interest? Because the ownership is common. You have common ownership and you have community of interest, right? Everything is common, interest is common, the ownership is common, and that's why it is called as undivided interest. And when he dies, right, then that property will devolve upon his coparsoners. Coparsoners, here you need to understand the people who come between the 4 generations. All right, that will go by survivorship and not by succession. Is it clear, Asta? All right. Now, according to Mullah, under Mitakshara law, the right to inherit arises from propinquity. Okay, that is proximity of relationship, right? So this is important. How do you get the right to inherit property in Mitakshara? Then that arises from propinquity, that is proximity of relationship, how close you are to that person, right? Now, Mitakshara divided blood relations into 3 classes. What are these 3 classes? Blood relation, Gotra Sapindas, that is Sapindas belonging to the same Gotra or family as the deceased from 1 to 7 degrees, right? So 1 to 7 degrees are called as Gotra Sapindas. You belong to the same Gotra. Second, Samanodaka, that is persons belonging to the same Gotra as the deceased from 8th to 14th degree. Okay. And third, Bhinna Gotra Sapindas, that is Sapindas belonging to a different Gotra or family from the deceased. So just remember 3 Gotras or 3 classes of Mitakshara because of which the blood relations are divided. First is Gotra Sapinda, first 1 to 7th degree, wherein you belong to the same Gotra. Samanodaka, it is also you belong to the same Gotra, but the degrees are 8th to 14th. And Bhinna Gotra, Bhinna is different, right? So you belong to different Gotras. Now the commentary also refers to a case of Pranji Vandas Tulsidas versus Dev Kuwarbai. It is a Bombay High Court case, right? Which commentary? The Mitakshara commentary, it refers to this. Okay, wherein a Hindu owning separate property. If a Hindu owns a separate property and he dies without a male issue, right? He leaves behind a widow, 4 daughters, and a brother, and male issues of other deceased brothers, right? There was one Hindu male. He dies. He's not having any male issue, but he leaves behind his widow, 4 daughters, and a brother, and some other male issues of deceased brothers. The court observed that the widow was entitled to a life estate in the property, and subject to her interest, the property would devolve to the daughters absolutely, in preference to the brother and the issue of the deceased brothers. Remember this case, because this is the first case wherein the commentary itself referred to this case, right? And what happened in this case was a Hindu male died. He is having a widow, 4 daughters, a brother, and male issues of his brother. Once he's dead, the property will go to the widow for, she's entitled to a life estate in that property of her husband. And subject to her interest, the property will devolve upon the daughters absolutely. It will not go to the brothers and the issues of the deceased brothers. Okay. Another case is Tulsaram Morarji versus Mathura Das, Bhagwan Das, and Pranjinvan Das. Okay? In this case, the court observed the decision in that case, and that in Pranjivan Das versus Dev Kuwar Bai. I'll just highlight this. Okay, so decision in that case in this Pranjivan Das and other cases have been steadily followed by the High Court in numerous unreported cases and by the legal profession. Any departure now from those decisions would cause much confusion and injustice throughout this presidency and no advantage that we can perceive. We therefore must abide by the principles which they clearly indicate. So Tuljiram Morarji case followed Pranjivan Das versus Dev Kuwar Bai. Okay, they said that we are not going to disturb the ruling that is given in Pranjivan Das. That's why we are going to follow Pranjivan Das. Okay. Another important case is Chote Lal versus Chunnu Lal. In this case, the following are the direct authorities on the point. The court said, okay, Sir M. Sauce in 1859 in Pranjivan Das Tulsi Das versus Dev Kuwar Bai held that a daughter takes absolutely when inheriting from her father. Chote Lal also upheld the decision that was given in Pranjivan Das. Okay, so these three cases were discussed in the commentary itself. Okay, which commentary? This commentary, which is written by this Sham Charan Sarkar Vidya Bhushan, that is Vyavasta Chandrika, daughter's right of succession. Okay. Now the court again discussed about Gotra Sapindas and Samonodaka. These are the persons who are connected to the deceased by an unbroken line of male descendants. That is all agnates. Agnates are through male side. So Gotra, Sapinda and Sambandokas, who are they? These are the people, they are connected to the deceased by an unbroken line of male descendants, which means the line is continuous. Nobody is dead, right? Unbroken line of male descendants, that is all agnates. The line is not broken, which means there is no cognate in between. Cognate is through females, right? And that's why they're calling it as unbroken line of male descendant. That is all agnates. And Bhinna Gotra Sapindas are persons connected to the deceased through a female. That is cognates, such as sister's son. All right. Now, Bhinna Gotra Sapindas are also known as Bandhus in Mitakshara. This literature is very important and that's why I included, right? These classifications are archaic and delineated now as class 1, which I told you in the beginning, class 1, class 2, class 3 and class 4 heirs under the Hindu Succession Act 1956 are of importance with respect to the property in question, considering its succession opened before the commencement of the Hindu Succession Act. Just a second. Okay. Is it clear to everyone, or do you have any doubts till here? Please ask me. Please ask if you have any doubts. Or is it clear? No doubts? Anyone? Why some cases are not reported by high courts? I couldn't get your point, Siddhant. Not reported by high courts. I couldn't understand. What do you mean by that? If you could elaborate that point, I would be in a position to explain. Okay, that I don't really know. That I don't know why they have not reported it. I have no idea about it. Siddhant, I'm really very sorry. Okay. So this is how the Gotra Sapindas of a person, they are like this, but this is not really for you to remember. But these kind of questions are asked in UGC NET if at all you're planning to prepare for it. Then, but I'm skipping this for the moment because so much of details will not be asked in CLAT, neither in AILET. Okay. Is it okay? But I have kept this part so that if at all, if you want to read in detail, you can go through this. Otherwise, it's not really necessary. I'll just, for your convenience. From here till here, you don't really have to remember, but you can gain some knowledge by reading this. Okay. All right. So the Sapinda relationship extends to 7 degrees reckoned from and inclusive of the deceased, and 6 degrees if you exclude the deceased. This is important. They might ask you the Sapinda relationship extend to which level. So it is 7 degrees inclusive of the deceased, which means if deceased is there, then it is 7 degrees. But if you exclude the deceased, then it will be 6 degrees. Okay. The wife becomes a Sapinda of the husband on marriage. And daughter's son is not a Gotraja Sapinda. He's a Bandhu because he's related to the deceased through a female. Anyone who is related through female becomes cognate and becomes Bandhu or Gotraja Sapinda, right? However, for the purpose of succession, he's ranked with Gotraja Sapindas. So here they are ranked. If you read this, you will get to know that how they are ranked. Okay. Now the court, the Mitakshara law also recognizes inheritance by succession, but only to the property separately owned by an individual, male or female. Females are included as heirs to this kind of property by Mitakshara law. Okay. So Mitakshara law recognizes inheritance by succession when only with respect to the property that is separately owned by an individual. Okay. Now judicial precedents. Okay. The court now discussed about the judicial precedents to come to a conclusion. Okay. First is Katama Nachiyar versus Srimut Raja Mutu Vijaya. Ragan, I'm really sorry. It's Raganadha Bodha Guru Swami Periya Odia Taver. Okay. So just remember one line, Katama Nachiyar versus Srimut Raja. That's it. It's 1863 case. Okay. On a complete reading of the judgment of Privy Council in extenso, this judgment, that is Katama Nachiyar, the following legal principles are called out. Okay. Court basically read this judgment and they said that these are the important principles. First principle is that the general course of descents of separate property according to Hindu law is not disputed. It is admitted that according to that law, such a property, that is separate property, descends to widow in default of male issue. Right? So there is no male issue. Then what is the general course of devolving the separate property according to Hindu law? It will go to the widow. Okay. It is upon respondent, therefore, to make out that the property here in question, which was separately acquired, does not descend according to the general course of law. Now, the respondent, if saying otherwise, then it is upon respondent. The burden of proof is on the respondent to make out clearly that the property in question, that is the separate property, that will not go according to the general course of law. And what is general course of law? That if there is no male issue, then it will devolve upon the widow. Now, third principle that emerged from this case is according to the more correct opinion, where there is undivided residue. It is not subject to ordinary rules of partition of joint property. In other words, if it a general partition, any part of the property was left joint, the widow of the deceased brother will not participate, notwithstanding with separation, but such undivided residue will go exclusively to brother. Now there is undivided property, or some properties remaining from an undivided interest. Then that undivided residue will not be subject to the ordinary rules of partition of joint property. Joint property is your coparcenary property, right? And what are the rules of partition of joint property? There are many, but it goes to coparceners within 4 generations, right? That's the basic rule. So if there is any undivided residue, I mean, just a small portion of a property, then that will not be subjected to the rules of partition for the joint property, which means it will not be covered under the coparcenary property, right? In other words, undivided residue could be, if it is a general partition, right? Any part of the property, if it is a general partition, then any part of the property was left joint, the widow of the deceased brother will not participate, right? If it is a general partition and some property, undivided properties residue is remaining, right? Then in that case, widow of the deceased brother will not come into picture, right? Why? Because that undivided residue will go exclusively to the brother. Why? Because maybe the brother could be in the that 4 generation rule. The brother's widow will not be given that property. If you follow the general partition rule, when there is just a portion or residue of undivided properties remaining. Okay. The law of succession follows the nature of property and of the interest in it. Okay. The law of partition shows that as to the separately acquired property of one member of a united family, the other members of the family have neither community of interest nor unity of possession. Okay, so if you have a separately acquired property, then that's your own property, that's your separate property. Then in that case, no other member of the family will have a community of interest or unity of possession. Unity of possession is common ownership. Community of interest is your undivided interest in that property. Obviously, when it is your separate property, other members of the family will not have these 2 fundamental principles of coparcenary, that is community of interest or unity of possession. Okay. Now, the next principle that emerged from this case, that is Katama Natchiar, was the foundation, therefore, of a right to take such property by survivorship fails, and there are no grounds for postponing the widow's right, any superior right of the coparceners in the undivided property. Okay. So what happens? The right to take such property means self-acquired property by survivorship fails, which means survivorship will not be applicable to the self-acquired property. And there are no grounds for postponing the widow's right, any superior right of the coparceners in the undivided property. Okay, because it is a separate property, then why are you postponing the widow's right to get the property? Right? And the last proposition, the Hindu law is not only consistent with this principle, but is also most consistent with convenience. All right. So the court finally said that if it is a self-acquired property, it will go to the widow. These principles we need. Yes, these principles you need to remember because this is an important case. This case, 1863, Katama Natchiar, that's the first case the court cited. And these principles are important. That's why I told you in very simple language. If you understood them, then you don't really have to remember word by word. If you have not understood, please ask me, I'll again explain.